various accounts, bank accounts, investment accounts, should be retitled in the name of the trust to make sure that they're also included as trust assets. But they are, once that trust is established and funded, then they're administering their assets really technically as trustees of their trust. One of the sub-myths of this trust is, when we ask about whether everyone needs a living trust, one of the sub-myths is that people are led to believe that they have a living trust, that upon death, there's no administration required. The trust document provides for a successor trustee, and that successor trustee acts like an executor in a will. They would step in, at least at death, if not before, to manage the trust assets. But they would step in and then be charged with administering the trust. And this is where probate process can have a little bit of an edge over the trust process. You go through the same steps of administering the trust after death as you do with probate, but not before the court. And if you have a trustee who doesn't follow the rules, doesn't follow the trust, that can create some problems. But both of these methods, whether you're using a will or using a trust, require some administration. If it's a will, it generally will have to go through the probate process. If it's a living trust, the administration of that trust generally will take place outside of the courtroom. Unless there's a problem or an issue, that trustee can always bring that trust into court to address issues. But essentially, both documents, whether you use a will for your estate plan or a trust or even some other devices, they're really just methods of transferring assets upon death. And in my practice, I try to determine what the best method is for each client. If people have very limited estates without many assets, they might do just fine with a will. If they have more substantial assets, they may benefit from a trust. But the concept is that the trust is active when done, when signed. It's a living entity now. It's a living trust, and it's in that those first trustees are managing those assets. A will, on the other hand, doesn't speak until death. I often get calls from people who will say, I'm the executor of my grandmother's will and I want to do this or that. And I always ask if grandmother died. No, she's not dead yet. And I say, well, you're not the executor yet. You need to go to court and be appointed after death before you're actually the executor. So that's a big distinction between the two. The will somewhat sits in abeyance, whereas a trust is a active living thing. Another difference between a trust and a will is that I mentioned the successor trustee would take over at death and transfer and distribute the assets to the beneficiaries. But the trust has a unique feature that would allow that successor trustee to step in before death and manage the assets of the trust, so that if there's incapacity by the current trustees, certainly dementia for an older person, then the successor trustee can step in and manage those assets for the benefit of those beneficiaries till they do pass. And then the job of the successor trustee is to transfer the assets on to the beneficiaries at that point. One of the other issues regarding a trust, by establishing the trust asset, it can have some benefits in the estate tax arena. A will just says, I give my estate outright to so-and-so, and that's what the court will allow. The setting up a trust allows people to take advantage of exemption trusts and to maximize the exemption amount for each of the trustors, thereby adding a tax benefit that you might not have if you just do a simple will.
That's great, Mark, and I think you really hit on something at the end there that speaks to myth number 4, and that is something that we hear from time to time, and I'm sure you would do as well, and that is, I will never pay estate taxes if I have a living trust.
I hear that a lot, and people come and they say, I need a trust because I don't want to ever have to pay tax, or I want to protect my assets. If you have an estate large enough, you're going to be subject to tax. And maybe we can flip to the next diagram. This shows somewhat of a typical situation in stage one. I described the establishment of a trust in a typical situation by a married couple, where both spouses would establish the trust, put their assets into that trust, whether it be their community property or their separate property. They can put all those into the trust and hold their assets as trustee. One of the things we want to avoid, if there is an exemption for somebody, for instance, last year the tax exemption per person for estate tax purposes was $3.5 million. We don't want to take the deceased spouse's estate and transfer it over to the surviving spouse upon the death of the first spouse and double up the surviving spouse's estate, thereby maybe creating an estate tax issue. So the law provides that upon the death of the first spouse, an amount equal to the exemption that's available in that year of death can be set aside in an exemption trust. This is sometimes called a bypass trust, a family bypass trust, or a credit shelter trust. But the deceased spouse's share of the assets, their community property generally, would go into that trust up to an amount of the exemption that year. And that would never become part of the surviving spouse's estate for estate tax purposes. The surviving spouse can receive benefits from that trust, can receive the income, can even evade the principal. But the way I like to explain it to clients, it's already gone through tax scrutiny and will never be taxed again when the surviving spouse dies and her marital trust then becomes subject to estate tax. One of the problems is, I mentioned the $3.5 million from last year. This year there is no exemption amount. This year there is no tax. So we're a little bit in limbo on how to deal with that. But this is an advantage of a living trust, where you can take advantage of the personal exemption amounts for each of the taxpayers and try to pass as much as you can tax-free. On the other hand, if someone has an awfully large estate, a $50 million estate, for instance, they're going to pay some tax somewhere down the line. It may be deferred. It may be pushed to the marital trust, and it may not occur until the second spouse dies. But there will be some tax. You can't avoid tax, estate tax, simply by putting your assets into a trust, which I think is one of the misunderstandings. The two trusts, if they're established, the exemption trust and the marital trust, then continue to be operated and administered by the successor trustee, which often is the surviving spouse. And then upon the death of the second spouse, then both of those trusts are distributed, the assets are distributed out to, generally, in the typical situation, the children. A few other items that we talk to our clients about when we put the estate plan together, whether it's a trust or a simple will, is first of all, one thing that should be mentioned is when we do a trust for clients, we will put the assets in the trust, but we also have them execute what's called a pour-over will. And the pour-over will gets that term by the fact that it pours assets into the trust, so that the will says, I hereby give my estate to my trustee. And it's a catch-all. It's there to help people in case an asset is left out of the trust. It just shows that all of these assets are to be funded back into the trust. It might require probate. But in addition to that will, it's always good practice to have the client sign a durable power of attorney. That is just for financial matters, and that is somewhat the same thing as the trust powers. It gives somebody power to deal with financial assets, but it's somewhat duplicitous with that. The other very important thing is the power of attorney for healthcare. This is sometimes referred to as the healthcare directive. It's sometimes, I think some people refer to this as a living will. I think that's a term that's used incorrectly and inconsistently. I'm frankly not sure what it means because I've heard it in so many different contexts. But what we really want to make sure is that a client signs a power of attorney for healthcare designating someone to make medical decisions for them if they're unable to do that. And then in both the state